Hello and welcome. Today's webinar for Mediation Awareness Week is on the top 3 tips to help parents prepare for family mediation. The reason that this is so important is because exposure to toxic levels of stress damages babies and children's growing brains. If parents can't sort out their differences at the end of their relationship, it can cause extremely harmful long-term consequences for children. Some of those changes in the brain can lead to anxiety, depression later in life, can lead to greater likelihood that they're going to be either victims or perpetrators of physical, emotional, psychological or sexual abuse of their partners and other people later in life. It's really important that children can grow up in a safe and secure environment to give them the best possible start to life. Our vision at Interact Support is Australian families living in harmony without the harm caused by interpersonal conflict. I'm Joanne Law. I'm the co-founder of Interact Support Incorporated, a social enterprise style not-for-profit working in the area of preventing family violence. I'm also director of Mediation Institute, where I help to train mediators and family dispute resolution practitioners and provide ongoing support for family dispute resolution practitioners and other dispute resolution professionals. I'm an NLP master practitioner. NLP is the study of how we code and sequence and record information in our brains, and how we, as a practitioner, can work with people to help them to change patterns of thinking and behaviour that no longer serve them. I'm a nationally accredited mediator under the Mediator Accreditation Standard System of Australia. I'm a family dispute resolution practitioner accredited with the Australian Attorney General's Department, a New Ways for Families coach, licensed with New Ways for Families from the High Conflict Institute in the United States, and a vocational trainer. You could say I'm a dispute resolution professional and peace catalyst. So our mission at Interact Support, and my personal mission, is to develop and support people and programs that help people to improve their relationships and resolve their interpersonal issues. My particular focus is on preventing violence during times of high risk, such as separation and divorce, by helping people to resolve their differences early. Basically, I do what I do because sometimes peace needs a helping hand. When I talk about peace, just to make sure we're on the same page, peace that I'm talking about is an absence of differences, or an acceptance of difference. If we can't accept differences, we'll often end up with disagreements. And so the process is we need to find some way to reach an agreement about what we can live with. If we can't resolve disagreements, they're likely to become a problem in relationships. And eventually, if nothing's done, they can escalate into disputes, conflict, even violence. When I talk about war in the context of families, all too often we see the terrible, terrible ultimate outcome where a parent kills the other parent or the children. War is when atrocities happen, things that we can't even imagine occur, and unfortunately they're occurring all too often in families in Australia. So we want to be working down here. We want to be living in peace, finding ways to resolve differences and resume a peaceful relationship. That's what I'm working for anyway. What we're talking about today is ways that you can help to prepare for parenting family dispute resolution, so FDR. family dispute resolution for parenting is compulsory in Australia, and it sounds like it's likely to become compulsory for smaller property matters as well after separation. And there's a very good reason why it is compulsory. It is the best option for children if their parents can work together to care for them before and after separation. So family dispute resolution is about empowering parents to make decisions about their children, with their children, for their children, so that they can continue to live a peaceful life. Using family dispute resolution frees up the family court for those who can't resolve their disputes themselves. So the courts get quite clogged up with applications from people who are never going to go all the way through. You'll see from this graph, and you might not be able to see it very clearly on the screen, but ultimately of the all of the applications that are lodged, only about 15% go through to judgment. The rest fall away along the way through either dropping out of the court system because they run out of money or reaching some sort of compromise throughout the process. And that happens because that's what the court's trying to do. They have targets relating to the timely completion of cases. So what they're hoping to achieve is 90% of final order applications disposed of within 12 months. That's not happening. It's probably more like 2 years or longer for some. In last year, this is from the Federal Circuit Court, where most of the cases that aren't on the extreme end go. Only 68% of applications made it through the court within 12 months. 90% of all other applications disposed of within 6 months. So there's a real pressure from the court to get your matter out of the court. They will try and help you to resolve things, get some sort of a resolution. The problem is you're already going to be spending a lot of money to get to court, and the agreements that you reach can be quite pressured. So they may not be actually the best outcome. And, you know, at least 70% of matters are resolved before the trial. So docket entry means when they've booked a date for the trial, which is going to be, you know, several months in advance, then there's a whole lot more work and expense required between that and commencing the trial. And then there's further attrition between starting the trial and getting your judgment. Now, when it comes to court and working with lawyers, time equals money. So using family dispute resolution saves both time and money. The hourly fee that you pay to a mediator is generally a lot lower than you pay to a lawyer, even if the mediator is a lawyer. The final point that I've got here is around the fact that making family dispute resolution compulsory, it's intended to overcome that conflict of interest that lawyers have in recommending that parents go to court. Ultimately, if you resolve your issues in family dispute resolution, it's going to mean that your value to the lawyer as a client is going to be, you know, significantly less. And so for some lawyers, that tension does mean that they recommend going to court when perhaps it really isn't necessary. It's really important that you inform yourself about the family law system and your options so that you keep control over things and don't get encouraged down a path that's not in your best interest. So this webinar is about the top 3 tips to help you prepare for parenting family dispute resolution. Number 1 is get legal advice. So it's really important that you go and talk to a family lawyer, that you get the right information and you ask the right questions. Number 2 is to use the 4 big skills. So when we talk about the 4 big skills, these are the 4 big life skills that make so much of a difference in pretty much everything you do. So those are managed emotions, moderate behaviour, flexible thinking, and checking yourself to make sure that you're not catching the negative emotions from other people, and also behaving in a way that's making things worse instead of better. And the third thing is learning how to negotiate well. And by that I mean learn about the collaborative negotiation style that's used in mediation and how to respond to demands. One of the biggest problems that I see as a mediator is that people can become very reactive. So rather than listening and finding out what's being proposed, they're reacting to what they think they hear. And they can often derail a process that's going quite well without even realising. So when I'm talking about legal advice, I'm talking about don't have your head in the sand, don't take advice from people who don't know what they're talking about. So make sure it's a family law professional that you're speaking with, a lawyer, a family dispute resolution practitioner, someone who actually has qualifications and experience in working in this sector. So a standard mediator doesn't have that qualification. And they've only, some might have experience, but it's hard to tell because they don't have the qualification. So what you want to find out from the lawyer, and it needs to be a family lawyer or someone who does a significant amount of family law work, because otherwise they won't be able to answer these questions. What you need to ask them is, what's the worst case scenario if I went to court? So by that I mean, what's the worst likely outcome? What's it probably going to cost, and how long is it likely to take? Now, this is a kind of a how long's a piece of string question, unless you give the lawyer information about your situation. So you need to book enough time with the lawyer to let them understand what your situation is, so that they can give you a probable cost based on other similar clients, how long it's likely to take based on what it's taking to get clients through the court system at the moment, and what's the worst likely outcome. So with parenting, unless there's been a high level of abuse towards the child, it's very unlikely that the worst outcome for a parent who's trying to see the children will be that they won't be allowed to see them. It's understood by all professionals working in this system that where it's safe for them to do so, the best outcome is for children to have a meaningful relationship with both parents. So that will be the presumption that you're working with or against, that it is going to be in the best interest of the children to have a relationship. Now, what form that relationship takes depends on how well you can work together as parents. The next thing you need to ask is, what's the best case scenario if you went to court? And once again, depends if you're, where you're coming from, what would be regarded as best. And best outcome is, what's the most time or whatever it is that you're looking for that the court's likely to offer, less what it's going to cost you and how long it will take. So that gives you a really good understanding of what you could achieve if you went to court, and what it's likely to cost and how long it'll take. Knowing that information really helps you to be more prepared and informed for negotiation in mediation. So you'll be able to tell when an offer's not reasonable, when a proposal should be rejected. Failing to get good quality legal advice will mean that you're very uncertain in mediation and easily either persuaded or perhaps refusing reasonable offers. To get this sort of advice from a lawyer, you've got to tell them the truth. So if you go in trying to make yourself look like you're the good parent and that nothing you've ever done could be used against you if it ended up in a trial, that means you're going to get an unrealistic unrealistic advice. They won't be able to tell you the risk of whatever that is coming back to bite you in court. So it's important to tell the truth to the lawyer. The process, there is privilege, which means that the lawyer generally won't disclose what you've said to them. And the other thing is, just remember that in most cases, your best case scenario is going to be your former partner's worst case scenario. And this diagram shows you a little bit more about what it looks like. So I've just used a man and a woman as an example, but certainly, you know, it might be a man and a man, or a woman who are the parents of these children. Sometimes it might even be a parent and a grandparent that need to negotiate for the shared care of the children. So ZOPA means Zone of Possible Agreement. So in mediation, both of you will be able to speak confidentially with the mediator. So they've generally got an idea of where the zone of possible agreement is. And that's relative to where you are at the moment, and you know how much better your position is likely to get if you went to court. So, you know, remember, once again, their best is your worst. And so, you know, you've got to think, if I can negotiate to get my position a little bit better, a little bit better, a little bit better, is it worth doing that in mediation, rather than, you know, just throwing the dice and hoping that things are going to get better in an order from the court or through the court process, against the risk that it could get worse. In mediation, you don't have to agree. So if what's been put on the table isn't better than your current situation, you can say, no, look, no, you know, no deal, and walk away no worse off, except for the mediation fees if you're using a private service. So it's, you know, it just makes sense to give it a go. The other thing that's really important is learning how to control yourself. Now, mediation, or rather Interact Support, has a post-separation parenting course called New Ways for Families. Some of the other mediation services also have various types of courses. Some have a free session, a group session that you can go to, and there's some really good information you can pick up going to that as well. But the New Ways for Families course is much more comprehensive than that. It's a 12-module online parenting course. Usually takes about 12 hours to complete. And among other things, it teaches the 4 big skills. So those 4 big skills are managed emotions, flexible thinking, moderate behaviour, and checking yourself to make sure you're not catching negative emotions from someone else. Now, when I at the very beginning, I talked about the consequences for children growing up in toxic environments, and the reality is many of us as adults did have challenging childhoods where we were exposed to high levels of family violence and tension within the home. We've got people that are coming to Australia who were raised in war zones where, you know, literally their lives were on the line, or who have suffered through the process of trying to get to Australia. So, you know, many of us have those scars from childhood that make it more difficult to control ourselves. Sometimes we haven't actually been taught these skills because our parents didn't have them. And if that's the case, particularly if that's the case, but for anyone really, working with a coach with the New Ways program is really powerful and valuable, not just for now, for the separation, but ongoing and for all areas of your life. So if your behaviour isn't something that you feel you can fully control, this could be a really good option for you. So in the course, just to give you a little bit more background, the first 4 modules of the course are around learning these skills. So learning how to cope with stress, how to solve co-parent problems with flexible thinking, how to avoid overreacting and lashing out, so moderate behaviour, and self-reflection. So checking yourself, making sure that you're not catching negative behaviours from someone else. And then the remainder of the course talks about how extreme behaviours and exposure to family violence affects your children's brains. So you'll actually find the science behind what I'm saying about these changes that will come if your children are exposed to toxic levels of stress. Raising healthy children. So what children do need to be healthy in mind and body. Child developmental goals, so learning to recognise if your children are struggling and helping them to develop normally. Then we look at some of the things like parenting schedules and attachments. So rather than taking a focus of what's fair for you, it looks at, what do your children need as far as their care. There's a module on using professionals to help, and it goes through the various professionals that work in the Australian family law system, so you understand their roles and aren't confused about how they, what they do and how you should work with them. There's a module on new partners and new families. So how do you integrate into a, blend in if you repartner? What's appropriate in terms of introducing children to new partners and things like that. There's a module on handling financial issues as co-parents, which can be a source of a fair amount of stress and tension. And ultimately how to avoid becoming a high conflict case. So when we're talking about high conflict cases, we're talking about the people that end up stuck in the family court, basically, bankrupting themselves in many cases, and perhaps even their parents, in a fight that just doesn't have to happen if you can take the appropriate action early on. So just to let you know, the cost of the online course is $198 per person. We offer hardship provisions, so if you can't afford to pay that sort of fee, then we can take a payment of whatever you can afford. We do ask you, we don't have any government funding, so we do ask that you pay it when you can. So if down the track you're in a position where you do have some money, we ask for you to make a donation equivalent or more than the amount that you were subsidised by. So there's no, we don't keep track of that or anything like that. It's really up to you. The other option, working with New Ways coaches. So Interact is training and supporting New Ways coaches, but they do work independently. So the best way to find out a coach that you might be able to work with is to find a New Ways coach on the Interact Support website. Now, the third thing I talked about is learn how to negotiate well. So negotiating in mediation is very different to the sort of negotiation you might do in a if you go bargaining at a shop or in a workplace situation where it might be more of a competing style where winner takes all. It doesn't work that way in family law, and it certainly doesn't work for children if you take that approach. What we look at is really looking to collaborate. So focusing on maintaining the relationship between you as co-parents, because that's really important for your children. If they can see you cooperating and working in their best interest, that's going to be absolutely in their best interest. The other thing is, it's really important that you're okay, but it's equally important that your co-parent is okay. And so both your needs and the needs of the children are very important. Collaboration is around trying to find a solution that meets all of those needs, those of each parent and the children. At best, we're looking for a solution that everyone is happy with. At worst, in mediation, we're looking for a compromise that everyone can live with. So sometimes, you just can't find, the perfect solution, but something that's going to be a bit better will make things a bit better. And, that's a good thing too. So what's really important with mediation, when you go to the mediation session, is to avoid that win-lose thinking, and not indulge in all or nothing thinking. So you'll know from your legal advice that it's not that you'd never see your children again. In most situations, it's going to be around how many nights, or whether you have nights with them if the child's very young, and that sort of thing. So sometimes it's better to agree to a trial, agree to something for now with a review later on, to get some movement, to build some trust, to show that you can actually work with the other your co-parent for the sake of your children. What they really need from you is to maintain a respectful relationship. Inside you may be very angry with them, you may be very hurt, you may really not respect them as a person right now, but for your children, it's really important that you show them, at least basic courtesy. And that means not forcing your children to walk across the no man's land of getting out of the car and not being willing to even acknowledge the other person. It's really difficult for the kids. It feels like they're in a war zone. Don't make your kids live in a war zone. And the second thing is, it's really important that you express your needs, concerns and thoughts about what's best for the children. So that's the other thing on this negotiation style matrix, is that sometimes people just take an avoidant approach, which means they're not thinking about the relationships, they're not willing to talk about what they need, really quite shut down. Now that can happen if you're fearful, and so it's very, very important that you speak to the Family Dispute Resolution Practitioner around your fears and concerns, because there's lots of provisions that they can make. And look, sometimes family dispute resolution isn't going to be appropriate. So, be open around those things. If it is something that can be done safely, it's really important that you speak up about what's important to you and what you think is important to the children. The other part of negotiating, so that first part was about your intention, what you're hoping to get out of the session. The second part is responding appropriately to demands. And by that I mean avoid being reactive. The reactive is when you just have an emotional response, you don't listen, you just react. It's really, really important that you take control over your responses to the other parent during mediation. If this is something that's been very difficult for you, get a coach, get a New Ways coach, learn the skills to be able to manage your emotions and your behaviour. So learning, and I'll just show you how to do this technique. It's really simple. And it's a great way to deal with complaints, with vague suggestions or comments, those nasty little asides that put you down, circular arguments, so when they're just coming back and back and back to the same point without making progress, or if you or they start to get emotional. So if you can feel yourself starting to get a bit reactive, this is a really good time to look at this. So first thing is ask, what's your proposal? So, you know, they might be saying things and so what are you proposing? What's your proposal? Ask the question and then listen carefully. Let them speak. Let them explain what it is. Then ask some questions to clarify. It's really important that you do this step. Make sure you understand what they're proposing. So ask some questions. So how do you see that working? Who'd do what? You know, whatever it is that you need to be really clear about what it is they're suggesting. And then the other benefit of asking those questions is it actually gives you time to calm down. It lets, you know, if you do the New Ways course, you'll learn all about the left and the right brain and how sometimes we can get stuck in one side or the other. So when you're solving problems, you need to be able to think logically and rationally. And so asking questions gives your brain time to get into that logical and rational side so that it is able to respond rather than react. And step 3, so first step is ask them, what's your proposal? The second step is to ask some questions to clarify. And then the third is to respond. So if their proposal makes sense, say yes, why not? If it works for you and if you think it's going to work for the children, say yes. If you don't, if you're absolutely on the spot confident that it will not work, then say no, I don't agree to that. But what I propose is, and do the same thing. So tell them what you think would work and why. And sometimes you know, you're not sure whether to say yes or no. So that's fine. You don't need to be pressured. In mediation, you should never be pressured to have to agree to something. You can say that you'll think about it. But I mean, that's not just being avoidant and saying that to get them off your back so that and then never giving a response. You need to be actually genuinely willing to think about it and give them a response. So you say, look, I'll think about it. Let's, you know, I think I need a break. Maybe ask for a private session with the mediator. Ask for a break. Just, you know, go outside for a moment, have a coffee, whatever. If you need time to just process what's being proposed before you respond. Or you might need to speak to an advisor. If you've repartnered, you might need to speak to your partner. You might need to speak to your lawyer or your support person or a close family member, whatever. So maybe you'll say, look, I think we should leave that for now. I need to think about it. I'll give you a response at the next mediation session or at the, you know, or at a given time. So that's the process for responding to demands or proposals. Ask what's your proposal, let them speak, let them talk about it, ask them questions to clarify and give yourself a chance to calm down so that you don't just react, and then respond. And your options are yes, no, or I'll think about it and tell you my response at this time. So take that away, try it. Look, try it with the kids. When the kids are being all whiny and wanting something, ask them, you know, so what's your proposal? What do you want me to do? It really can make a big difference. So I'm from Interact Support, as you know. Some of our services that help with parents trying to reach an agreement is firstly with information. So we have a service called an Interact Consultation, which is a family law goal setting and information session. So customised information. It's not legal advice, but it can be used to help you prepare for legal advice. The other service that we have is the New Ways for Families course and referrals through to the New Ways coaches. We offer family dispute resolution. Within Interact itself, we only offer online dispute resolution. So our services are designed for people that are struggling to access standard services, so you can get in quickly and resolve things, even if you are waiting for a government subsidised service for a longer term solution or whatever. It can take quite a long time to get into those services. We also offer high conflict family dispute resolution. So this is for families where perhaps you've been given a Section 60I certificate but you don't want to go to court, or other alternatives like shuttle mediation aren't appealing. So our high conflict dispute resolution services are a program, so they include the New Ways coaching and either video mediation or mediator facilitated negotiation. If our internal services aren't suitable for you, then we can refer you out to independent family dispute resolution practitioners who offer traditional, sit down in a room mediation, and also family lawyers who can provide you with legal advice. And the final step in the services that we offer is Interact Support offers help for parenting or property consent orders. So we can help if you do need to make your agreements that you reach in mediation legally enforceable, then we can help you with that. So, okay, well, this is our final slide, just our contact details. So you can phone, send us an email, visit the website. So Interact Support, we have a dedicated site to the New Ways program as well, which is newways.interact.support. So what I hope you take away from this is the 3 tips were: get legal advice. It is worth paying for good quality legal advice so that you understand your rights and obligations in regards to your children, and what's likely to happen in court and what it's likely to cost and take. That's going to prepare you to really make better decisions in mediation. Number 2 is to make sure that you can control yourself in the mediation process. So that's around managing your emotions, moderating your behaviour, using flexible thinking so that you're able to consider alternatives and not get stuck, and also being aware and checking in on your own behaviour and emotions to make sure that you're not catching negative emotions from the other person. So learning or remembering to use those 4 big skills. And finally, learning how to negotiate well. So the absolute benefit of that collaborative negotiation style is that if you can reach a win-win solution, then it's going to be sustainable. Rather than trying to force someone into an agreement that will probably not last outside the room, and certainly won't be something that you can work with together, well, it's just not worth it. It's not worth it. So unless you can reach a win-win solution, it's not going to be something that makes it easy to co-parent. And ultimately, if you're working together, if co-parenting is easy, that's going to mean that it's a more peaceful environment for your children to grow up in. And ultimately, as parents, I hope that that's your goal. So thank you once again, and please get in touch if we can help.